Yeah, you file an interim application for release of the appellant for his sister's marriage. I also served the.
I have to take instructions. I have to take instructions.
At the request of Mr. Katkia, who needs more time for instructions, list on 6th September.
The 6th.
What? When is the marriage?
16th of September. All right.
Supplementary list item of
6th September.
supplementary list item of 4.
Wait, please, madam. Lord, the IAs today are for consideration. Under 389, it was specifically adjourned, and I believe the LCR is also available. Lord, what is before your lordship is the judgment of conviction under section 302 and the order of sentence to undergo life 10,000 fine in default 4 months RI, my lord.
Do you have instructions, sir?
No, I don't have any.
All right. Just put down this bail application is 871,
My lord.
871 of 2022.
But yes, applied to yes,
Applied. Mr. Katkia, who needs more time for instructions, list on 13th September.
supplementary list item of 5.
The deposition copy is not with me. Let's say they maybe adjourn 1 week.
You just try and get a soft copy from the court single cost. All these depositions and all that, you will straight away get it from the soft copy.
That's it.
At the request of counsel to the appellant, just put down this IA number 931. 932, we say till the next, the realization of fines shall remain stayed during the pendency of appeal, that 932 is disposed of. 931, in the earlier matter, the fine part is, that's disposed of, stayed in. 931, we say at the request of counsel for the applicant. Less than 13th September.
13. Supplementary list item of 6.
All right. This delay is condoned. What is the bail application number? There's no bail application.
There is a bail application and there is that is 1 bail application.
1003. Sorry. The realization fine will allow 1003 2022. Counsel for the appellant states that we will be supplying the copies of the depositions today. List on 14th September.
Supplementary list item of 7.
Now, this delay is condoned.
Delay is condoned.
It's not been admitted, but
I am appearing for the conducting counsel, Mr. Mahatma. He is not in the.
that's all right. So we have to just admit the appeal.
Yes.
Admit the trial court record the requisition, paper will be prepared and supplied to counsel within 8 weeks. Including the list of final hearing thereafter.
Supplementary list item of 8.
Item 8, I think the same feature. Well, in the third round of litigation by the same person, the same.
In the last date of hearing, my lord asked me a question. If it is a class action lordship, whether PIA lordship, in that view lordship, the judgment lordship, I have given the citation lordship, the AR 1981, SP Gupta, Akhil Bharatiya Sansad, RI 63 lordship. Anyway, tell us what the matter is. Matter lordships are at 31. Then it was granted by the government of the Energy Department, which says lordships. Ministry of section this section for generating electricity set up transformer switch gear cables or other apparatus equipment used for the purpose of the site there is to intended to be used for generating station. Used for housing and operating staff of the generating station and electricity generated by water, including stocks, gas, this is what for us dams, reservoirs and dams, we already have gas, but does not substation. These are last paragraph, Lordship, the supply of electricity by a generating company to the housing colonies of expensive. This petition township. The generating staff of its of generating station will be part of the activities of generating electricity. For supply of
The direction, you have the OHPC.
Yes,
Come to page 20.
yes.
Is a direction to the OHPC to take up the matter with.
We have already disposed of that application. If you lordship should just give me a moment, your lordship must see the cause title. What is he representing is the Lakshmi Bazaar Baluka Sangha, which is completely the market area.
Correct.
And the guidelines which has been given by the central government as well as the state government is only for the housing colony, the township that the
That's, that's if you come to page 20. Yes. That's what they have said there. But they have issued directions to you. Yes, and that has been taken. No, taken only one. Where is it now? Just see that. Yes, my lords. Page 20. Third paragraph from the bottom. Hence, Chairman OHPC.
yes, my lord. Is directed to take up the matter with CO, TPC or DL, Collector, Anvil, Water Resources Department to facilitate power supply to the non-OHPC consumers through DISCOM. Once they make necessary application to TPC or DL.
So are you writing this application to DPC?
See, I am being in case any certificate process may be completed. It's associated
What's wrong with that, sir?
First, in the world, it's yeah. So I don't
Bazaar, sir, you're having shops in the bazaar. It's a commercial area in the township, it's not a residential area. This whole thing is called running the bazaar.
let's see, sir, the township looks really, I will be the township looks is a region too. Small units are not actually
Concession power.
Somebody, that's why we should apply to this. This is not. That's a kind of consider.
This is the second round of litigation at the instance of the present petitioner. Earlier, this petitioner had filed the petition civil 11294 of 2022 with the prayer for the direction to the Orissa Hydropower Corporation Limited, bracket OHPC, to continue electricity supply to the township of Rangani Dam site, bracket Lakshmi Bazaar. That petition had been disposed of with this court on 19th May 2022 with the direction to the Secretary Department of Energy, Government of Orissa, to dispose of the petitioner's representation dated 6th April 2022 after giving them hearing. Pursuant thereto, the petitioner was heard and the impugn order has been passed on 28 July 2022. It's only paragraph. The petitioners have sought to take advantage of an order dated 8 June 2005, Ministry of Power, Government of India, providing for supply of electricity at concessional rates. No, exemptionally, the housing colonies of a generating company or township housing the operating staff not to from obtaining a license to supply of electricity. The impugn order notes that the petitioner and the local inhabitants of the Lakshmi Bazaar open quotation are not the operating staff of the generating station, unquote, and therefore are not covered under the above order of the Ministry of Power. Stop. It must be noticed here that the distribution licensee for the area in question is Tata Power Company, Orissa Distribution Limited.
Central Orissa Distribution.
Central Orissa, Tata Power Central Orissa Distribution Limited, bracket TPCODL, which has the sole authority to provide supply to the consumers, including the petitioner. Stop. That was the matter. The direction has been issued in the impugn order to the OHPC to take up the matter with the CEO TPCODL to facilitate power supply to the non-OHPC consumers through the TPCODL by 30th September 2022, once the petitioners make an application in that regard to TPCODL. Paragraph: the council petitioners agreed by the above direction, since he insists that there should be no requirement for the petitioners to apply for electricity supply to TPCODL. According to him, since the petitioners are local inhabitants staying in the township, they cannot be required to apply separately for electricity connection, and they should be covered by the order dated 8 June 2005 of the Ministry of Power, Government of India. Paragraph: having heard Learned Counsel, the petitioner and Mr. Nandal and senior counsel for the OHPC appearing in advance notice, the court is of the view that the facility granted by the order dated 8 June 2005 of the Ministry for Government of India was only for townships where operating staff of the United Station are staying and not all local inhabitants. Stop. Secondly, the petitioner is representing the Lakshmi Vizar Bainika Sangha and therefore is not in strict sense carrying on in a strict sense only using the place for residential purpose, but in fact for a commercial purpose. Paragraph. Consequently, the court finds no error having been committed in the impugned order, requiring the petitioner to apply to TPCBL for a connection and for further directions to urge PC to provide the necessary no objection certificate for facilitating the exercise. Full stop. The impugned order itself notes that the entire exercise should be completed by 30th September 2022. Until such time, no coercive action will be taken against the petitioner. Full stop. The court is not inclined to add anything further to those directions. Consequently, the court finds no merit in this present petition and is dismissed as such.
Supplementary list for orders.
So right there, another petition is pending by the Water Resources Department, maybe for the single year. The last paragraph that this order will not be binding. Item 9. There is single appellant list. I will read premature release.
Premature release, same order.
So 10 is also single appellant.
10 is also same.
Single appellant.
Item 11.
Similar.
Same.
It's only one appellant, right?
Yes, of course.
Okay.
Item number 12.
Single appellant.
Same.
Item number 13.
13 I don't have to file. So much.
Let me just see.
Hearing to the appellant.
Single appellant, is it?
Yes.
I see. Same order.
Item number 14.
Total out of the two appellant list, appellant one will be released prematurely.
Okay. You see, as far as appellant number 1 is concerned, the report of the DIG presents confirms that he has been prematurely released. So therefore, the present appeal will continue as far as the remaining appellants are concerned. Accordingly, the cross title appeal be changed as Kandarpa Kumar Sahu versus State. Has the paper books been ready? No. The paper books be prepared and supplied to parties within 8 weeks. Thereafter, include the matter appeal in the list of regular hearings.
Supplementary list for admission. Item 15.
Your item number 15. Why is it before a DD? Yes. Tell us, item 15, it is referred to the larger list. That's right. By judgment letter. 6 May 2004. Yes. Yes, tell us.
Assuming I don't know, I am supplying a soft note. Seniorism VC will argue the same. Soft note along with inert citation.
It's a case manual which was referred to a division bench
Yes.
for a question whether magistrate can take cognizance, but finally report is submitted in a case, a trial by Court of Sessions. That your lordship relying on the Mr. Dhawal has also was appearing that Jilla in view of Jilla Singh case, it is directly covered. Therefore, the order of the magistrate is illegal violent, that should be quashed because it is only under section 390 are the accused.
What do these documents say, Mr. Katkar?
Well, say out of 10 accused persons who are named in the FIR, plus while filing charge sheets, it is 6 charge sheets was filed and 4 were left. So that is the reason most of the question cannot whether because it's a session plan offense which is there. So whether master can be counted or not. The master can continue. This time so the master will or other question. No substance is changed here also. And I'm reading from this criminal number 217/2006. 217/2006. Yes. There cross is at intermediate 3 of the interim order. Running the 6. Under the above circumstances, the question remains whether this court can take cognizance and add these persons as accused persons who are not charged by the police and also add offences against all applications and issue process against them. So in the next phase, the level could bring some judgments. That is from the top. Well, I'm reading from page 6. From the bottom, there are divergent views on this point. Our honorable court in Sangam Kisai versus state of Orissa reported in 2001, 552. Rohingya versus state of Orissa reported in 2002, 123, question 13. Government of Rohingya versus state of Orissa. Government of Rohingya versus state of Orissa. And Chotan the state of Orissa. Held up in a case trial by the court of session. The magistrate can take cognizance if the person is not charged by police. The offensive judgments are delivered by single benches to the honorable court rely upon additional of the Papist court. In Kishore Singh and other stated another. Yes, Kishore Singh case of the wherein it is held that magistrate could not have issued process against the person who has charged it. Such persons could be added active person except the power and section 319 of the CRPC. So some evidence of victims are brought and record the original prior. But another single which is not on the statements are 612 and 686 relying on the decision on the participant in some and another reporting 75 customers. The commission for participants in the master's power under 190 CRPC is taken away to take cognizance of an offence relates to the person whose name doesn't find its in the charge sheet submitted by the police. A demand Mr. Power in Dr. Supreme Court versus Orissa against reporting people 530 OCR 460. Whenever the master is not bound to accept the opinion of police after initiation of the case. The veterans collected during the registration of the government police justify the prosecution of an actual can be summoned by the court to face prosecution. In November, Basir and others it's a good law. And another including putting one share of participated. So the master can add persons and active person not charged by police. So also we have power of 190 of the CRPC to add offences on the basis of the evidence collected by police. Therefore, in the opposite offense of law and receiving evidence of the I find then 5% evidence constituting offences in section 147, 148, 348, 394, 304, 379, 208 by 139 of IPC, and 25 by 27 arms act. Against Rikal Vena, Victim South, Kondu Samu, Babu Mistake Ramu, or the Sumasiva. Hence, governance reckonings then on the section 147 and 40, 340, 302, 309. So this is the cross. So the persons have not been charged, but governments have been taken by the government.
Last time.
Session single government has been
Last time.
constitution and officers is better primary and that. Without paying, they are putting him 306. When a very fast paragraph of judgment will also find
This order is not placed in all the matters. Copy of this order should be placed in all the connected matters. You put all the constituents here. They're not placed in it. Why not?
the constitutional bench in the case of foreign party against state 14, 366. The very fast paragraph is also filed that because it is three instances initially. Because two dimensions, two items on one side, or the other side. I mean to say, this is a two should say consistent proceed. This is one side. And Sri India should with the state of this is the other side. That is base. But when the matter is taken up on what is based, it is found two of the arguments. And also one it's also that is Ranjit Singh instead of Punjab. That is very fast paragraph. That is why all this doctors will I mean constitutional bench. So five of these bench have answered in a way that aspect and understand evidence of the offences which the Norwegian has applied. Suppose one 10 accused persons and 5 of charged in police and 5 of them. So these are aspect of offences. The aspect can be convinced for this person if national files. That means there are some matters against these persons. But if it is session trial offence, then section 193 will come into operation. Suppose is it the case of trivial coup? So 5 persons have not been charged. So again, those 5 persons have the power to proceed or to process. So that means section 106 are arguing.
That is what these petitioners are arguing. That these cases the magistrate could not have taken cognizance.
Yes, ma'am.
These are all 303 cases.
Yes.
So the magistrate could not have taken cognizance.
Session is not common also.
In 19.
And that same I also in the case of conviction sir. Yes, there one section correct. So even the court of the power, we used to process second active persons, even the court find it's charged. And there is difference in there. So there is
what is your submission, sir? In these cases, could the magistrate have given the so that's the simple thing.
So
So we just write the retail judgment, all these revision petitions are allowed. And the impute orders of the magistrate taking cognizance as hereby quashed. It will open to the prosecution now to proceed in accordance with law by requiring the cases to be committed.
Because that will be subject to the trials in respect of those who have been committed still pending.
No, so it can now proceed to the stage at which it is. Each case will be at a different stage.
Your Lordship may note one thing. Your Lordship stayed the complaint case proceeding.
Right.
But the trials of those persons, my lords, who were committed, no stay order was passed in respect of that.
Right.
Some of these trials may have been over by now.
Yeah, that is a different thing. So
Must have ended in a conviction or
if a trial is concluded, we cannot intervene that. So wherever the trial is not yet concluded, the matter will proceed from the stage where it is in accordance with law. In my case, the part of detailed law.
because paragraph 18 and 19 of Horvitz case was also kind of
Under the judgment on which Mr. Katkia is relying, he may supply the copies, my lord, because last time we have also mentioned the judgment on which we are relying. If there is some judgment, my lord, Mr. State Council is relying.
absolutely by first of class. To my learned senior.
Copy, let me matter be listed on another date file so that we will reply also.
One thing I want to.
Now, sir, that's it.
Zillesing is always totally different. That is in a complaint case. Zillesing.
Some complaint cases, sir.
Yes.
This group are complaint cases. So he got to judgment, sir. Basically, there's no difference as far as the legal position is concerned. He's also saying the same thing.
I'll send the 3 judgments to all my seniors to answer. Supplementary list, I don't know, 16.
May please go last. In this case, I'm challenging the order under Annexure 1, my lords. Well, I did. Application for restoration of the writ petition has been rejected by the Honorable Single Judge, my lords. There is a case of removal from service and recovery of 78 point some odd lakhs from the petition on, my lords. No, it was dismissed for non-prosecution, my lords. Who's the other side? Why should it not be restored, sir, before the single judge? That is what it is, my lords.
My lords,
Yes.
the point is,
Yes.
it is not the case. At his stage, there is delay. Because he has filed the writ petition after 3 years of the order.
It's all right, sir. These are individuals pursuing.
And my humble submission, even writ appeal also was filed delayed. So CMPL after 9 and 7 days. Writ appeal also filed after 30 days.
It's all right. And delayed filing the writ appeal is condoned. The challenge in the present petition appeal is to both an order dated 1st May 2019 passed by the single judge, declining to condone the delay in entertaining a recall application to recall the judgment of the court in writ petition civil, my lords. Case 5 of 2010, which is dismissed on 18/2/2016. Paragraph. The ground on which the application has been rejected is that there was a delay of 907 days in filing CMAPL 470 of 2018. Paragraph. Having perused the application, the court is of the view that since the petitioner is an individual pursuing his matter of dismissal from service, removal from service, a more lenient view ought to be taken, particularly since he is pleading illness. Full stop. Consequently, the impugned order dated 1st May 2019 is hereby set aside. This will mean that CMAPL number 470 of 2018 is allowed. Full stop. Consequently, IA number 216 of 2018 for recall of the judgment dated 18/2/2016, my lords. 18/2/2016 is hereby recalled, and writ petition civil 8657 of 2010 is restored to the file of the single judge for now being proceeded with in accordance with law. Will stop. The matter will now be listed before the roster bench of the single judge. It's on 26 September for directions. Okay. The writ petition will proceed on the basis of the pleadings as they exist.
Right. We have not filed counter because lately we have received notice. So we file the counter in this case.
Petition.
Yes.
Oh, I see. The reply be filed to the main writ petition by that date.
Supplementary list item number 17.
May it please, your lordship. Well, this is a appeal before lordship. The candidature for a RO dealership of the candidate has been rejected by the authority and which was challenged in a writ petition, and the writ petition was allowed. And against the order of Honorable Single Judge, I am before your lordship. Your lordship may straight away come to page 66, your lordship. I'm sorry, page 35 first. Page 35.
What's the date of the impugned order?
Lord, it's Lord,
10th March.
yes, Lord. my lord.
What is the operative portion of the order?
Your lordship would find it at page 163. Serial number 163.
So all that has been asked that you should scrutinize and verify the title offered for the land held by the petitioner.
Lord, the finding is that fact before that, Lord, a little bit fact is to be explained, your lordship.
No, you have not implemented this order.
My lord, the 8 weeks time was allowed, your lordship.
On 10th March, madam.
My lord, before that, filed this writ of appeal, and I have tried my best to get it listed, your lordship. My misfortune that it could not be listed. Once it was listed and I was ill that day, your lordship. That is,
Anyway, you have not implemented it till date. You have not implemented the impugned order till date.
Miller, because of the pendency of this petition.
So you can give yourself a stay. That's the most convenient thing, madam.
No, Miller, I have.
File an appeal and then just sit pretty. If somebody asks you, say, no, I filed a writ appeal.
No, Miller,
No order on the stay, but you can give yourself a stay. Deemed stay.
No, Miller,
That's what it means.
I have tried my best to get it listed, your lordship. Once
That is enough. That is enough. Suppose a contempt petition is filed. Will you say that I have tried my best?
No, your lordship is right, but that's a predicament on my part. And one day it was also in list, but I was running.
What is wrong with this impugned order?
The order, lordship, may I see? Page 163, your lordship.
Yes.
Para 7.
Yes. Dependent of the affidavit.
Yes, deponent of the affidavit said, petitioner's father expired in the year 2009, having behind his elder brother and himself as his only legal successors. He did not say that petitioner was the only legal heir or successor. He omitted to mention his mother and 2 sisters. The subsequent fact is that the younger brother, mother, and 2 sisters joined to make the petitioner sole owner of the offered land. In the circumstances, it cannot be presumed that there was false statement or misrepresentation. Thereafter, your lordship. The next paragraph, lordship, the court has perused above extracted contents of the affidavit in context of a subsequent register's release deed dated 28th April 2015. The complainant before the order
says only legal heirs. It's para 6 of the impugned order. The second paragraph of the affidavit.
Yes, that is my case, my lord. That is not my case. He has filed the false affidavit, my lord.
All right.
My lord.
Notice till the next date of hearing, the impugned order shall remain stay. List of notice additionally be served on counsel appearing for the writ petitioner before the length of the writ petitioner stroke respondent hearing. It's on 14 November. Supplemental list for
My lord, may I pray for an interim order? My application is there.
just read. Madam, you're not listening to what is being dictated. Yes.
Item 18.
Item 18, my lord. In first item, your lordship kindly see the order dated 5/8/2022. It is a part-heard matter by my lord Justice S. Talapatra and my lord Justice M.S. Sahu, my lord. Order dated 5/8.
All right.
Going to put September.
No. Does it say it's part-heard?
Yes, my lord.
Last line will also tell you
Since the impugned order, previous order indicates that the matter is part-heard years before the same bench.
My lord, in the second item,
On 6 or 15, my lord. On 6th of September or 15th, my lord.
next item, second. There is a premature list.
my lords, I was appearing for the appellant therein and I moved a bail application which has been allowed. I don't understand how my lords he has been released prematurely, my lords. I need to take instructions on that.
In 107,
Yes. 107, my lords, may look at order dated 28/2/2020.
or maybe the release was after that, sir.
But here must just I have to bring to lordship kind of notice only to assist this on court. So the occurrence took place on 15th December 2013. So the premature release was 28th February 2020, only 7 years after. So section 433A of CRPC has to be rate relevant section 432. At least the person should be there when for 14 years.
Then how did it get released?
That is plus
Is the report, sir?
the report. I don't have the report. So that is there.
But can a copy of the report be supplied so that
Copy of the report be supplied to counsel to the parties who want to take time for instructions.
the lordship may grant us 4 weeks time?
All right. List on 1st November.
Supplement number 9.
First item, CRL 12627, your lordship can list on 6th or 15th September.
How can they all connect? Come separately.
The common paper book has been prepared.
Reach out.
Item number 19.
May I please allow this? Plaintiff's custody since my lord 2512 last 10 years plus a lordship. And the convicted under section 302, 324, 326, 307 of IPC and the sentence for RI for life a lordship along with other sentences a lordship. The I filed for bail a lordship that is on list. The
Deposition copy was supplied to us.
already supplied.
No.
Yes.
Which is not supplied?
Deposition copies are not supplied.
Already supplied and the paperwork already ready. That is what the there.
Yeah, people could be collected by counsel for the state from the registry. List on 2nd November.
All right. Supplementary list item 20. Item number 20. I am for the informant. In this.
All right, none appears to the appellant. It appears that he has also not collected paper book from the registry despite several intimations. In the interest of justice, list on 3rd November.
Before that, I mentioned specialist item number 35. मैं तो जिसमें तो along with MSc 986 of 2000 means arbitration lists.
Item number 1. Item 1, my lord, in the meantime, the honorable appeals court has already decided matter of declaration. Nothing is not an order.
All right, in view of the judgment of the Supreme Court in civil appeal dated,
1 minute, my lord. However, the honorable appeals court has granted liberty to seek.
dated 25th July 2022 in civil appeal 4914 of 2022. Bracket Mahanadi Coalfields Limited versus Messrs. IVRCL AMR joint venture. The present petition is dismissed. However, it will be open to the petitioner to seek other appropriate remedies as may be available to the petitioner in accordance with
Similar matter is item of 3 and 7.
same orders in 3 and 7.
3 and 7, sir.
Same orders. Yes.
Item number 2.
Made, please, item number 2, Milots, I appear for the respondent, Milots. I have been instructed. to appear.
None appears for the petition. My lords, I am appearing for the petition, my lords. My lords, your lordships is pleased to adjourn this matter signed in light of the Supreme Court judgment in NN Global Infra versus Indo Unique Flame, my lords.
Milots, may I make a petition?
My lords. Awaiting judgment of the Supreme Court. List on.
Milots, sometime in end of September, Milots, would your lordships please, Milots?
28th September, 30th September, 30 September.
Please, great.
Supplementary list item number 4.
In this case, your lordship may kindly see order number 19, my lord. Order number 19 dated 13/8/21, my lord.
My lord, I have been directed to file in affidavit. I am filing in course of the day, my lord. So let it be taken up next week, my lord.
Mr. Guru, learned counsel appearing for the opposition.
Petitioner, my lord.
Says that he will be filing the affidavit during the course of the day. List on 23rd September.
Okay.
Supplementary item 5.
In this case, my lord, the respondent opposite party has filed a arbitration appeal. Due to non-listing of the same, this present arbitration petition cannot be decided because your lordship order is there.
It is stated that the appeal filed by the opposite party is still pending adjudication. List on 14th October. Supplementary list item number 6.
Wait, please, my lord. My lord, the last arbitrator that was appointed, Shri Abhinayan Mishra, we had challenged his appointment under section 12 of the Arbitration Act. My lords, because we are seeking an independent arbitrator to decide the disputes. And my lords, I am relying on 2 judgments. One is my lord's judgment in the High Court of Delhi, Ratna Infrastructure Private Limited.
Yes.
And the second is my lord's the Supreme Court judgment. My lords, the first judgment deals with the 1940 Act, and there my lords had decided that because there's an amendment clause which deals with amendments later on. Therefore, under the 96 Act was applicable, and thereafter, my lords, the issue was raised regarding the independence of the arbitrator. There, my lords said because amendments still also apply, therefore, my lords appointed a new arbitrator, beholds the appointment made by them. And similarly, the Supreme Court judgment, that is the same thing which has been done by the Supreme Court, my lords. There, the arbitration was pending since 2000, my lords.
What do you say, sir?
My lord, so far, my lord, contents is concerned regarding the lordship has been counter affidavit filed. Specifically, this court has directed twice, and the named arbitrator is there.
And no, but we're supposed to name the arbitrator anymore now.
My lord, regarding that judgment, I will take instruction in the matter because I have not gone through this.
Learned counsel for the petitioner relies on the judgment of the Supreme Court in Ellora Paper Mills Limited versus State of Madhya Pradesh 2022 3 SEC 1. And the judgment of the Delhi High Court in Ratna Infrastructure Projects Private Limited versus Meja Urja Nigam Private Limited 2017 SEC Online Delhi 7808. Counsel for the opposite party seeks time for studying the said judgments. 14th October.
Yes, I will raise my lord.
Item number 8.
My lord, item 8, I am for the respondent. Kindly 7 days time may be granted to file the counter. It is almost reply be filed within 4 weeks. Joined up for the next week. 21st October.
Supplementary list item number 9.
But item 9, today we are filing the counter for the department. It is 12. Arbitration under the 12(5) of the Arbitration Act, my lord. So
not
counter today itself, let's make it.
joined up for the next week.
Mobilization.
List on 21st October. Mobilization.
Supplementary item 10.
11 time no, na.
Item number 10.
Settlement talks are in progress. The court is informed that settlement talks are in progress. 21st October? Yes, all right. Item 11. May I please, Your Lordship? Lordship, this is a 11/6 application. The last date, Lordship had issued instruction.
My lord,
Item 11, sir.
my lord is 11, my lord is adjourning.
You know, like item 11, what is your instruction?
We don't have an instruction, or she give some time, my lord.
All right, Mr. Padi seeks some time for instructions.
Mr. Kashyap name may be reflected along with me.
All right,
Yes, yes.
it's already written. List on 28th October. Grateful, Lord.
This way. Special list. Case admission item number 1.
None appears dismissal on resolution. Interim order is vacated.
Special list, case admission item number 2.
Same order.
Item number 3.
Same order.
Special list item number 4.
Same order.
Special list item number 5.
Same order.
Special list item number 6.
Permitted to withdraw, my lord.
Council petition seeks leave to withdraw the presentation. Dismiss is withdrawn, interim order is vacated. All right.
Special list item number 7.
Same order is 1.
Special list for orders item number 8.
None appears dismissal on resolution.
Special list for orders item number 9.
None appears dismissal on resolution.
Special list item number 10.
Same order.
Special list item number 11.
Same order.
My lord, this case has been transferred to Chief Advocate, my lord, and delay is there, my lord. Delay notice may be issued. Either he has appeared or not, I do not know. We don't know, sir. Whom are you for? Again? Whom are you appealing for? Which is the item you are appealing in? I am for the appellant. In item 11. 11. What are you saying? My lord, brief is handed over to the concerned advocate. Sir, then you don't worry about it. Counsel for the appellant states that brief has already been taken away from him. None appears to the appellant dismissal on resolution. Item number 12. Appellant. Case notice will be issued. No. What's the matter about? Matter no dual matter. Sorry? No dual. Injury case no dual. No driving license. Driving license. No driving license. Case notice. What's the delay, sir? Delay. How much delay? Ah, 1 year, 11 months, sir. There's a delay 1 year, 11 months and 16 days in filing this appeal. The explanation offered in the application for conditional delay is totally unconvincing. The court is therefore not inclined to condone the delay. This case number 1096 of 2005 is dismissed. Consequently, the MACA is dismissed. Specialist item not 13.
What's the delay?
No, without recording my concession, award is 12,000. Without recording my concession, well, that's not right.
Since the awarded amount is just rupees 12,000, the file does not consider it appropriate to interfere in the matter. Moreover, there's a delay of 26 days. All right. Consequently, the appeal is dismissed, leaving the question of law open.
Specialist item of 14.
65,000.
Same order.
Specialist item 15.
For enhancement. For enhancement and for the appellants. And Kotti I have already filed. The injury case. So there is a actual injury, the learned tribunal has awarded only 5,000.
98 days.
My lord,
98 days.
can you give me ground?
Yeah, let's see the ground.
The appellants are the
were unable to get, no, not for 2 years, 2 years, 98 days. But the delay of 2 years, 98 days, filing the appeal, the reason given in the application that he was in a remote place in the district of Kianjar and was unable to come to the advocate chamber
It's a very distant.
is not sufficient enough to condone such an extraordinary delay of 2 years and 98 days. Consequently, the application is dismissed, the appeal is dismissed. Yes,
Specialist item 16. 16, 17 also same matter.
same.
Item number 17.
None appears to cease in opposition.
Specialist item 18.
None appears to cease in opposition.
Specialist item number 19.
Insufficient address. What is the matter about?
My lord, one is the owner of the vehicle was said expired in the trial. In the tribunal, he was said expired and liability was the insurance. On the insurance, in the
You India actually this. What is what is the ground? Where is the impute order? Where is it? Which page? What is after the appeal memo? Allowed the claim of 1,52,000 against the claim of 5 lakhs. Yes. What is it? The injury? Injury, your lordship will see the injury. But has notice gone to the insurance company, sir? The injury, just see the page, lordship. 1 minute, sir. Has notice gone to the insurance company? Yes, yes. A Das and Associates. What are instructions, sir? He wants enhancement. He's paying 5 lakhs. If you've given only 1,52,000. Are you willing to go for the permanent local adat? Both parties should explore the possibility of settlement through the permanent local adat. The petition will be listed there. The appeal will be listed there on 23rd September. If no settlement is able to be arrived at, then the appeal will be listed before this court on 28th October. All right.
28th October. Specialist item number 20.
20 delay is 1 month. Delay is 1 month. Who is the insurance company here? Some 58 rupees, your notary fee not affixed. Sir, you not affixed notarial fee. Notary fee I have paid. I have paid the notary. All right. On 10/2/2009. It is stated the notarial fee has been paid, but there is no notice to that effect. On 10/2/2009. The registry to check up. What about notice position?
Requisite not filed.
Requisites were not filed, sir, for over requisites 11, 12, 13 years now. Requisites and notarial stamp I have already filed. My notes is from. Not paid, sir. What it's not filed. Again, I will file. So it's taking years. No, my order sheet shows it was filed on 10/2/2009. Oriental insurance. You are there for Oriental insurance. You say notice, he accepts notice for Oriental insurance. The matter be referred to the permanent local adat. Same order. The same date also. I will, so we come on 28th October. You serve a copy on the
Item 21.
21, the delay is 4 months. Notice was sufficient on insurance company. Which is the insurance company? Insurance company. NIA. National Insurance.
New India Assurance.
National or New Year.
Who was that other person? New India.
New India Assurance.
Who's for national usually?
No, I am for the.
You are for national. Okay.
Here is national is not a party and New India Insurance Company is party in that case.
No, this matter is natural or new?
New India Assurance.
That earlier matter was New India. New India, so it's an earlier matter, no? Earlier matter. So this was, I think Mr. Das was New India. So Mr. Das, you say, a copy of the paper will be served and Mr. Das today itself. Same order, refer to the local dialect. If it fails, you have to come here and hold it. Right, entire copy. Item 22 number. 22. Item number 22. How many matters? 21. Item number 20, LAC 972 of 2005. 972. Oh, wait.
21.
Yes, this is my matter. Local. Let it go to local. No, this 972, who is the insurance company?
972, we are not.
Yes, how much? 972. United India. Yes. Who's appearing in United India? Anyone appearing for United India? So he accepts notice. Same order. Local direct. Item 23. Here it is. Yes. Yes. Same simple. National insurance. Who's the national insurance?
Yes, I have.
Mr. Das. All right.
No, appeal memo may be served.
Appeal memo be served on him. Same local dialect. Same date, 28th October. All these matters. Item number 24.
The state is the appellant. The challenge against the award.
Postal requisites not, no requisites.
And land is also involved very sometimes.
If the postal requisites were not filed for over 16 years now, the court does not propose to grant any further time for this purpose.
And there is a limitation also.
Yeah, it also appears to be badly time barred. Therefore, the appeal is dismissed.
Item 25.
24 days only. All right, delays condoned. AD from opposite party number 1 not received. What do you want to do, sir, 16 years later?
AD has not, solicited return has not been come from the owner of the vehicle. Owner is no way involved. Because in lower court, insurance company has satisfied the amount. So I am coming for the enhancement before your lordship.
National insurance. Who's for national insurance?
I am the retainer of the company. Lordship may direct to serve a copy. I'll take it, sir.
Full copy, the paper will be served on the counsel for the national insurance. The matter be referred to the permanent local dialect and will be listed there on 30th September 30. If no settlement is possible, it will be listed before the court on 4th November. All right.
Specialist item 26. Item number 26.
None appears to assist in opposition.
Item number 27. 27, my lord. I had a refugee student, my lord.
You can't suddenly wake up one fine day and file requisite changes.
Against
the enhancement, is it?
No, against the dismissal order of the tribunal, my lord.
Or at notice, national insurance. Serve a copy of notice to the revenue respondent returnable on 30th September. Not 30th, sorry. 28th October. 28th October. Right.
Item 28.
Court fee of 827 not paid, sir.
I filed a petition for exemption of court fee.
Why?
There's a provision that court fee can be exempted.
No, why? What's the reason? Can't simply because the provision doesn't mean you get exempted. You have to make a ground, sir, for exemption.
Yes, I filed it when I filed a petition for exemption of court fee.
What is the ground?
Yes, please.
the appearance of the more elected person there.
No, what has happened to the claim? Was the claim allowed? Not allowed?
It's a case of death, my lord.
Well, how much has been paid?
Only 34,000 has been awarded, my lord. In a case of death.
You in the assurance, serve a copy of Mr. Das. Be referred to the permanent Lok Adalat on 30th September. List before the court on 11th November. Right.
So, specialist item 29.
My pleasure, Lordship. For minute delay of 13 days, I have taken notice, but
Addresses and all have left.
my lord, I may be permitted to take notice to public paper publication.
No. What's the amount involved?
My lord, our is 2 lakhs. Here, my lord, father has been filed the case for the deceased son. In the meantime, during the pendency of the case before the tribunal, the father has died. Father was died and the brother was substituted. When I kindly see my ground, though they have not stated in the column number 23 of the claim application, they have stated no other legal son is there. But that major brother will have taken specific ground member. Major brother is not dependent. Actually, I have received just now the file from the company. Minor, can you take out next week, minor? I will satisfy.
The request of counsel the appellant list on 21st October.
Minor.
Specialist item 30.
30 minutes, please, your lordship. I am for the appellant. And the cross check also filed by the another from the side of the claimant. In this case, my notice had gone. Responding now 5 and 1. Answer with the remark of father, name of the father is defective. Responding now 5 is the my lord. What's the amount involved here, sir? My lord, 1,05,000. Nothing, no point. The amount awarded amount being just rupees 1,05,000 for a death. That my lord, the bed is not inclined to interfere. My lord, the appeal is dismissed. 50% liability has been settled against these operations. All right, sir.
Specialist item 31. 30,000.
30,000. Since the amount is just rupees 30,000, the court is not inclined to interfere. The appeal is dismissed.
Specialist item 32.
None appears to now.
Item number 33.
Item number 33, Milos. Here, Milos, well, obviously, I have taken notice through special messenger. Because what's the amount involved? If the amount involved, fraud has been perpetuated. Then what's the amount involved? 12 lakhs. And what's the limitation? 9 lakhs 51,056. And limitation 87 days. Here, what happened, Milos? Accident occurred. Police submitted charges against this driver that roadside.
Who's appearing? You are appearing.
I have filed all the owner has given the affidavit and also that never went to Orissa. What we did not that high force vocal I have filed by additional evidence. Everything first. What do you say?
That notice has gone for assignment.
Who are you appearing for?
I am for the claimant, man. I am for the claimant. So that my lawyer can think that the owner is gone. Somebody is filing.
Before the rapid ambulance, I have alleged that vocal number, everything before then additional evidence. That we never know that never came to Orissa. Everything fraudulent, Milos. By perpetuating fraud means I have you lose your amount. If you have anything to say, you simply allow the petition.
No, madam, I am not.
He's the payment amount is going to yes. And you have nothing to say. Very strange. What you don't know the client using the entire amount.
No. I am not legal. So far the objection of my lawyer.
Sir, if this objection is up, you will not get a single person. Is it true?
No. You should all the matter be, whoever filed the objection, I don't know. If that is the correct.
No, all these petitions, but the answer was not correct. They filed a protest petition. Third question filed. Information not filed protest petition. But under the information pushed to file. Now, why the filed protest petition on that basis our has been pushed. And the lordship say I filed Bhakalaknama, her affidavit, her letter to website plus through initial post, everything by the additional evidence plus.
And I have taken the observation on the 29/8/2007, I have taken notice as a through special message regulation.
What has happened? This is item 33, no?
Yes, madam, item 33. Special message that I have taken.
Requisites not filed.
Yes, no, sir. I have taken additional evidence limitation through special message regulation.
Hasn't gone.
I'll throw through substituted notice, you'll also see.
Fresh notice be issued on the correct address of respondent number 5. Returnable. 11th November.
11.
Item 34.
Plus 34 is a old appeal, but as I find, it was filed within 90 days, my lords. But there are some other compliances were not made within the time, maybe technical delay. I will file a petition in lordship, but appeal was filed within 90 days, my lords.
No, what's the amount involved?
Amount is 1,06,000. The point, my lords, he was traveling as a passenger in a truck.
So already death. In the case of the amount being only 1,06,000, the court is not inclined to interfere. The appeal is dismissed. Yes.
Special item 35.
So, Mr. One appeal initial 9/6/2007, I died, sir.
With the respondent having already died, the court is not inclined to interfere. It's all right. We don't want to chase the legal asset.
What's the delay here? The delay is 13 days.
Delays condoned.
Well, amount 50,000, 174,000.
Right. You say the amount being awarded just 1,50,000.
Passengers. So we can't make arguments when it's not on board with the research. We are certified of filing that 9/6/2007. What happened is the common government law. In 9/6/2007, I filed certificate.
Whenever it comes up, it will come.
The may but if act on police law, they are traveling as a passenger in the private vehicle.
It's all right. Substantial subs. These are, you say,
9/8/2007.
You say the special notice that is taken on board. There's a common award in both these petitions which has been challenged. The amount involved in that for the amount awarded for the deaths of the passengers is as little as rupees 1,50,000.
In one case, 1,50,000, another 1,74,500.
And another case, 1,74,500. In MACA 1007 of 2007, the respondent has even died. In these circumstances, the court is not inclined to interfere in these appeals, with the amount being insignificant. The appeals are accordingly dismissed.
The amount having died.
Yes, obviously. Hello, I am appearing for the respondent number 4, that is the owner.
Item 36.
Number 36 and one passer.
All right.
Item 37.
Item 37, my lord, this is a claimant's appeal. Both the counsels who are appearing in this matter are one of them, the A.N. Sahu. He has become a legal officer, my lord. We do not have the file. Your lordship, allow me.
Counsel to the appellant states that he does not have the file. As and when the file is traced, a revival application will be filed. The appeal is dismissed.
Item 38.
None appears dismissed and not prosecution.
Item number 39.
No instructions. No instructions dismissed.
Item number 40.
None appears dismissed and not prosecution.
Item 41. 41.
None appears dismissed and not prosecution.
Item number 42.
Maybe you see. Last one, since there is a case and counter in both the cases are tagged together, I will appealing for the subaltern. The present case, there is admitted that the civil suit pending between the parties, my lord. Or the case, my lord. This case, my lord. Since civil suit is pending, my lord, there is a case and counter case, my lord. That is my lord. Who's appealing for these parties?
Ah. You also kindly see pro judgment.
Now I want to come that side, sir. So many 3 mics are there. Why are you all struggling for 1 mic? Now, since civil suit is pending, my lord, and case and counter case, my lord, I would like to distance on the perspective that still relying that knowledge then pass the proceeding, my lord. Since only dispute, my lord. In next item, also 9, he has appeared, my lord. 9 and 10 appear. I will agree that both charges are agreeable. That the criminal proceedings between them can be quashed in view of the pendency of civil matters between them. That is the matter in both these matters. Just takes the prayer clause and all proceedings consequent that we hereby quashed. All right. All right. All right.
Item 43.
None appears dismissed from opposition.
Item number 44.
None appears dismissed from opposition.
45.
None appears dismissed.
Item 45, liberty may be granted to all.
Counsel the petitioner seeks leave to urge all the points raised in the presentation at the appropriate stage in the trial court. It is so ordered. Petition is disposed of. Interim order is vacated.
Specialist item 46.
Yes. My lord, item 46. The learned SDJ has passed the interim order under annexure 3 is without jurisdiction, my lord. After under section 8B of the Family Court Act says that after establishment of family court, no magistrate have or exercise any jurisdiction or power under chapter 9 of CRPC.
But the respondent has not been served. No such address.
Yes, my lord.
You better take all these points before the permitting the petitioner to urge the grounds raised in the present petition to the appropriate stage in the trial court. The petition is disposed of. All right.
Specialist item 47.
None appears dismissed on non-prosecution.
Specialist item 48.
None appears dismissed on non-prosecution.
Item number 49.
State appeal, my lord.
Delay.
Delay is there and the amount is also not so.
All right. There is a considerable delay in filing the present petition. The amount also involved is not significant. For these reasons, the court is not inclined to interfere. The appeal is dismissed.
Item 50.
Same order.
Item number 51.
Item 51, no instruction. No instructions dismissed.
Item number 52.
One customer manner.
Item 53.
None appears dismissed in opposition.
Item number 54.
For appellant already dead. All right. Counsel the appellant states that the appellant is already died. The appeal is dismissed as having abated.
Specialist item 55.
None appears dismissed in opposition.
My lord, I am appearing for the respondent. I am present.
All right.
I am appearing for the respondent company, national insurance company.
All right. Item 56.
None appears dismissed in opposition.
Item number 57.
51 crossover. Passover.
Item 58.
None appears dismissed in opposition.
Item number 59.
Well, I am for the respondents, my lord. I am filing a cross objection today, my lord, in course of the day.
Someone appearing for the petitioner, sir. For the appellant, there is none appearing. Dismissed in opposition.
I am filing cross objection. Well, that may be taken up, my lord.
So, 60 appeal, nobody is appearing now. You can't file cross exhibition, sir.
I am filing almost filed, my lord.
It's a 2006 matter, not today. Yes.
Your lord, there's a family in distress, my lord. Family in distress. Only earning member died, my lord.
16 years, you can't come with the cross objection, sir. Sorry. Yes.
Item number 60.
Obliged.
None appears dismissed in opposition.
61.
My lord, in 61, I am through VC, my lord.
In
61, the petitioner has passed away. I pray to Lordship may grant revotive, but this arises out of a civil suit relating to recovery of property. If they
Right.
ask, they will choose. Subsequently, they will, my lord, your lordship may grant them liberty, my lord.
All right. You see, the appellant, the petitioner stated have expired. The petition is dismissed as having abated with liberty to the legal representatives of the petitioner to revive it if any cause of action survives.
Much obliged, man.
Item 62.
62, my lord, on behalf of Mr. Dayanand Patra Pasir, my lord.
All right. Who are you for?
I am for the petition. I am for the petitioner, my lord.
Pass over.
Item 63. My lords, I am appearing, I am filing the affidavit.
Ask them to take the water from there and go.
It's the affidavit of the opposite party stating that he has this.
From that side, there's water that side.
My lords, he has stated in affidavit that he has received the money towards full and final satisfaction.
All right. There's an affidavit of the petitioner stating that the money has been received in full and final settlement. No. An affidavit has been filed with the petitioner enclosing
My lords,
copy of an application filed under section 257 CRPC by the complainant stating that he has received the complete amount pursuant to a compromise. That was the matter taken from the prayer clause and all proceedings consequent thereto hereby quashed.
May I mention matter, item 62, in fact, my junior colleague mentioned it as I am appearing for petition. In fact, I am appearing for opposite party.
Oh, 62 non appears dismissed and non-prosecution.
item 64.
Lordship, on behalf of P. Mahapatra, permitted to withdraw my lord.
Counsel, the petitioner seeks leave to withdraw this petition, dismisses withdraw.
In the meantime, the marriage was organized by opposite party petitioner, my lord.
Item 65.
65, your lordship directed the state to produce the 164 statement and directed us to file the marriage certificate. The marriage certificate was applied. They were married and living happy conjugal were obliged to
We have received the as a council of both parties list on. The request to council of the parties list on 14th October.
ruled.
Specialist item 66.
66 not pressed.
No instruction. Yeah, no instructions, dismisses not.
Filing a memo to that.
I am there for the opposite party, your lordship.
All right,
Item 67.
In practice, your lordship.
not pressed, dismissed.
Item 68.
May it please your lordship. Lordship, may I be permitted to place on VC lordship?
Yes, yes.
Lordship, I am submitting on behalf of Mr. Late Satyabrata Pradhan, sir.
Yes.
Lordship, the affair, the complaint case arises out of the dispute is of civil in nature, Lordship. In the first initially one affair was lodged in the year 2013, 12, Lordship. In Annexure 5, Lordship. Page 35, Lordship. And for the self-same offense, another complaint case has been lodged in the year 2013 in Annexure 2, Lordship.
Yes.
Lordship, basically for the self-same offense, 2 affair has been lodged. And on the basis of the second complaint case, cognizance has been taken by the learned JMFC, Lordship.
Who's for the other side?
Pardon me, Lordship.
Actually, in this case, my name is there in the cause list, but I don't found the file in my office. But in the I verified the matter. Mr. J. Katakia's name is there in the order sheet on the last order sheet. That was on 12/8/2022. Mr. J. Katakia's name is there.
No, but that's for the state, sir. There's a private party here.
Opposite party 2, your Lordship.
I don't have any instruction in this case. And also file is missing.
So what do you do?
If some time is allowed, I will verify the file from the
Council appearing for respond, but 2 states that his file is missing and he needs some time. At his request list on 11 November, interim order to continue.
Obliged.
Lordship, name of Mr. Avash Manji may be reflected in the cause list, Lordship.
Sorry?
Lordship, the name of Mr. Avash Mahanti may be reflected as the previous learned counsel is.
Counsel for the petitioner's name be reflected. All right.
Obliged, Lordship.
None appears dismissed in opposition.
Item number 70. Item 70, may I please, Your Lordship. Here is a case, Your Lordship. I have challenged the cognizance under annexure 14, Your Lordship.
What's the offense in the
409 and 506. The petition, Your Lordship. Lordship, annexure number 1 is the agreement executed between the petitioner and OP number 2, Your Lordship.
so fourth copy? All right.
And after that, Your Lordship, by annexure 2, I seek some place to stock my rice, Your Lordship. The FCI didn't receive the rice, they didn't provide me the place. The RRC also didn't provide me the place to stock my rice, Your Lordship. Custom rice, milling rice, Your Lordship. And pursuant to annexure 2 series, all my representation, the respondent by annexure 4 at page 59, Your Lordship. I started giving them representation since February 2013, Your Lordship, page 48, which the respondent in the year 2014, Your Lordship, in the August 2014, Your Lordship. And the rights were within the joint custody of the miller as well as the government officials, Your Lordship.
And can urge all these please permitting the petition to urge all the pleas raised in the present petition in the appropriate stage.
At the time of charge, Your Lordship.
Yes, yes.
Considering the annexure 15, Your Lordship.
Walk away, sir. Yes.
Considering annexure 15, that may one line reflected.
All right, all right.
Item 71.
None appears. No instructions dismissed.
Item number 72.
None appears dismissed in opposition.
Item number 73.
None appears dismissed in opposition.
74.
May I please, Lordship? Lordship, in this case, my prayer is to pass the order dated 23/9/2015, passed by additional District Judge Rahul Kale, Lordship, that is directing and also directing me release the property in my favor, Lordship. Lordship, in this case, so
what's your property?
So iron scarf material, Lordship.
The appraisal rejected.
Yes, Lordship.
Well, it's page 18, para 5, Millers. That is the impugned order.
Yes.
Millers, the truck was seized and Millers, the waybill and the person who has purchased everything, Millers, doesn't match with the petitioner. Millers, para 5. That is the submission of the state. So and so appearing strongly objected and supported the order of the
truck has no authorization to transport
scrap. Show that the scraps were purchased.
What is that? Show the scrap was purchased by you.
Lordship, he is the real owner of the property.
Where is that to show that?
There is not.
You have to produce some document in proof of that.
Well, as in fact, para 6, the third line, the petitioner who filed a waybill reflected the truck bearing number, that's a Jharkhand number, was authorized to transport the scraps. This truck bearing number 1, which is Orissa, Millers.
So I'll pass the detailed order. Please, dismissed.
Item 75. That is 73, Your Lordship. I missed it.
73.
My Lord. Your Lordship, say I will raise all the points at the time.
Permitting the petition to urge all the points raised in the present petition at the appropriate stage petitions.
Item 75. Obliged, Lordship.
None appears dismissed in opposition.
76. Your Lordship. Here, my Lord, the order related to 205 application is under challenge, my Lord. That is of 2015. The complainant of number 2 has filed a complaint case, my Lord. For which the Lord Beneficiary has taken the cognizance, and thereafter the petitioner being a senior correspondent, my Lord, has filed a 205 application before the court, my Lord, that has been rejected. And subsequently, NBW has also been issued, and the Honorable Court will please to stay that NBW law.
So that alone we can, you fix a date, sir. You say the petitioner has come to this court agreed by an order dated 5th December 2015 passed by the JMFC Chandigarh in the ICC case number 580 of 2015, declining the petitioner's application to section 205 CRPC. As a result, NBW has been issued against the petitioner. On 18 January 2016, this court stayed the NBW, and that stay has continued since. Paragraph. In the circumstances, while setting aside the impealed order, it is directed that the petitioner will appear before the JMFC Chandigarh in the aforementioned ICC case number 580 of 2015 on 2nd November 2022. The NBW is quashed. The case will thereafter proceed in accordance with law. Grateful.
Item 77.
Pardon your lordship on item number 75. Please grant one of them.
No, there's no adjournment here, sir. You argue the matter or it's dismissed.
After the file is missing though.
Then whenever the file is traced, you revive it. You say counsel, the petition states the file is missing, the petition is dismissed. With liberty to the petitioner to revive it in case the file is able to be traced.
Item 77.
None appears dismissal, no persuasion.
Item number 78.
Item number 70, no instruction.
No instructions, dismissed.
79.
79. In this case, the petitioner has challenged filed the challenging criminal proceeding. In the meantime, under section 13B, mutual consent, the party has been divorced each other, and the family court Cuttack has allowed the divorce. And
there, the petitioner produces a decree passed by the family court Cuttack, dated 12th December 2017, dissolving the marriage between the parties. That is the matter, taking the prayer case and all proceedings consequent that we have acquired.
Criminal proceeding will be quashed.
Yes.
Item number 80.
Legal lordship, my lord. To petitioners, my lord, police officers, they assess the order of cognizance as per Annex 3, my lord. But cognizance has been taken under section 323, 341, 294, and 34 of the IPC. Basically, on 2 grounds, my lord, I have raised. My lord, the sanction has not been applied, and no private education, my lord.
What is your instruction on this? Item 80?
Is item 80.
No sanction granted.
No, I don't have for the file.
Counsel for the state seeks time for and is request
complaint has appeared, my lord.
11th November.
Item 80 may please, I mean, appearing on behalf of the informant, my lordship.
All right.
Item 81.
My lord, one thing, my lord, I want to submit before my lords. My lord, I was taking instruction subject to correction from the my lord, council of the opposite party. In the meantime, complaint is there.
Is there anyway?
The council will say, my lord, the council will say, but I was asking to my clients, my lord. If that will show, my lord, then my lord, will be dealt as per section 256 of clause 2, my lord, on the death of the.
Very well. On the next day, please.
Right. Item 81.
Interview stay may be controlled.
Item 82.
Item 82, which is claimant's appeal. Appeal for enhancement of the hour amount and for 82.
82.
None appears dismissal not resolution.
Item number 83. Question of proceeding on the compromise with the parties minute. The document number 3 has been affidavit at page 17 annex of 4 minutes. The dispute between the informant and the petitioner due to some transaction in mobile phone minute. That is at page 17 annex of 4. Notice has gone to the opposite party, they have heard enter appearance.
Who is the opposite party number 3?
He is the injured minute. That were affidavit at the 17 annex of 4 minute. Offense 341, 294, 326 minute.
The affidavit of opposite party number 3 stating that she has already compromised the matter is at annexure 4. There is nothing on record disputing the veracity of the said affidavit. Accordingly, criminal case number, all the taken over clause and all proceedings consequent thereto are hereby quashed.
Item 84.
None appears to assist in opposition.
Item number 85. My lord, the sanction has not been granted, but the learned magistrate has taken cognizance.
Yes, sir. One more case you have to take instruction.
I'll take instructions.
The request of counsel of the state who wants to take instruction. List on 25th November, interim order to continue.
Specialist item 86.
None appears to assist in opposition.
Specialist item number 87. 50,000.
Amount being insignificant, the court is not inclined to defer. The appeal is dismissed.
Specialist item 88.
I am for the claimant 75,000 has been made. I'm paying for the appellant insurance company. Our main ground of challenge is there is no insurance policy. That is where our people know.
Significant, the court is not inclined to defer.
The interest amount is 9%, that must be reduced to 6%. It's 6%. No policy, there is no policy. Very much.
Specialist item 89.
This is the claimant's appeal for enhancement of our amount and for fixing the liability against the
Insurance company, sir. Who's the insurance company?
I'm for the insurance company. That's not two.
The matter will refer to the permanent local audit, where it will be listed on 30th September.
My liability has been fixed against the owner, my lord. So that should be adjudicated, my lord. Because my lord, policy number was disclosed in the claim application. And the policy, Xerox copy of the policy was filed for the MSCT, which is available on record, my lord. That has not been dealt by the MSCT. That is the main point, my lord, liability.
No, whose liability is it, according to you?
Liability is against the insurance company, my lord.
So we're referring to the permanent local audit. Let them figure it out.
Yes, ma'am.
List on 30th September. If the settlement is not successful, let's go for the court on 25th November.
Specialist item 90.
I suppose you know where the permanent local audit is.
My lord.
The Ain Seva Bhavan.
Yes.
Lord, defendants revision against reversing judgment law. During pendency of the revision law,
90.
during pendency of this revision law, appellant present petitioner, sole petitioner, and present opposite part number 1 and 2 has been died, Lord. I have filed 6 number of IA to substitute abatement and limitation laws. But that
none of the IAs are shown, sir.
I have not been served with the IA.
No, IA number 33 is not. This copy, Lord. IA number 33, 34, and 35 in respect of the present petition number. So far as IA number 36, 37, 38, and 19. So far as the present, the operative number 2.
You are for the respondent. What's the main matter about?
Main matter. This is a money shoot, my lord.
What's the amount?
Amount, my lord.
5,600.
5,600.
Sorry?
5,600, Lord.
5,006 rupees.
But I am disputing the relationship.
5,000 rupees, sir, you are fighting.
But Lord, I am disputing.
Yes, sir. Your own fees will be more than that.
So, Lord, I am disputing the relationship between the landlord and
sir. For 5,000 amount, they waste the High Court's time like this. The amount involved being just rupees 5,006. The court does not consider it appropriate to entertain this revision petition at all.
They have also lost the first appeal also. They have lost.
No, in suit, I have the suit declared in favor of the landlord.
All right. The petition is accordingly dismissed.
The matter of the IAS at this. I have not regularized, Lord.
All right. IDC has not been applied. I see. Oh.
I'm a pardon, my lord. Item number 55 is the list. Both the parties have been appeared. Your lordship may send to the permanent local, can we settle there? Item number 55, I missed the list, your lordship dismiss it for default. Item number 55.
55,
my lord.
Which is the insurance company?
Insurance company is the new Indian.
So Mr. Das, national insurance.
They have already appeared. Both the
I don't know what you're saying, sir. It's very difficult without anyone being here. Suddenly, if you pass an order, you already passed an order. You file an application, right?
Ma'am, I missed the list just now.
Sorry?
I missed the list.
But nobody's here, sir, the other side.
No, other side has already appeared, my lord, in the case. I don't know, kindly have a glance to the.
Who's the other side?
Mr. SR Patnaik.
There's no SR Patnaik today.
Yes, my lord.
Yes, we have to be. Now you have to tell him to be here. Or it is a counsel the petition appeared. The order is recalled. List on 9th September. You better ask him to remain present. My lord. Next Friday.
I beg pardon. Item 90, your lordship may dismiss that.
You are dismissing it. Yes.
The passport. Specialist passport matter, item number 36.
Millard, I am in virtual mode, Millard. May I take your lordship kind permission to join in it, Millard? Millard, oblige, Millard. Millard, in this matter, Millard, the notice with regard to control. Am I audible to your lordship?
Yes. What's the delay, sir?
Oblige, Millard. Millard, the notice has gone to the respondent.
142, sir.
Millard?
142 days delay.
Millard, I have to take notice through order 5.
No. There's a delay of 142 days.
Yes, Millard. There is a delay of 142 days, Millard.
Yes.
And notice had gone to the.
No, forget notice. Convince me.
Millard, I will satisfy your lordship, Millard. I will satisfy, Millard.
Yes.
I have already taken the regions, Millard. It is Millard. I have taken the regions in para 5 and 6 of my application, Millard.
These are not valid reasons.
Millard?
These are not valid reasons.
I could not follow some problem maybe in
It's all right,
audio.
sir. I am able to follow you. That's fine.
Millard, Millard, I am unable, Millard. Your lordship, am I audible to your lordship or not? Because some problem in voice in my device, Millard.
No, you are perfectly audible, sir.
Millard, there is a delay of 142 days.
So the reasons given by you for the delay are not convincing, so I'm not inclined to condone the delay.
Millard, your lordship may kindly reappreciate the regions, Millard. Regions, Millard, at the relevant time, the vacation was going on.
No, that has nothing to do with it. There's even, in fact, a vacation code also.
Millard, vacation was going on. There was no scope on the part of the London Council appearing for the
vacation period is always excluded for limitation. This is beyond that.
Millard, that could not be excluded for that reason. Millard, 15 days. Millard,
all vacation periods are excluded when limitation is calculated. This is too basic. Please don't argue on that now.
Millard, that so far that period of exclusion is there, Millard. In obtaining of my certified copies, Millard, 15 days are there, Millard, which can be deducted from the delays.
After deducting that, there is still a delay of 162 days.
142 days.
162, sir. It is 142, correct. 142.
Yes, 142.
Till 142, there is no explanation for that.
Millard, case is that, Millard, that application, that claim application, it was disposed of by the London MSCT in a camp court, Millard, and record was not available.
We are now in merits. We are now in delay. Yes.
Millard, I am just explaining about the delay, Millard. For what reason delay it has been done, Millard. obtaining the certified copy since matter was disposed of by the learned MSCT in its camp court and record was not available. When record was available, Miller, by that time the summer vacation it was going on.
These are all not valid reasons at all. You have a whole panel of lawyers. These are not valid.
There was no scope on the part of the learned counsel appearing for the insurer to make application for obtaining of the certified copy.
They all practice in the bar. They all practice in the bar. These are not valid reasons. Yes.
Miller, if that these are the reasons and the subsequent reasons, Miller, is that Miller, when there is also some days of delays that I have already pointed out. When the matter was remitted to my office, Miller, by that time that another puja vacation is going on and 11 days of delays were also there, Miller. I have already avoided in para 6, Miller, of my application. May I just read it out, Miller, for your satisfaction?
Yes.
That the regional office by letter dated 11/10/2007 sent the relevant papers document to the office of the counsel of the company that is at Cuttack, that is to my office, Miller, with the instruction to file the appeal under section 173 of the MVR against the aforesaid imposed order award passed by the learned tribunal. The same was received during the puja vacation. Thereafter, the concerned counsel, after receiving those papers, documents, and after examining the same, drafted and filed this appeal, Miller, on 8/11/2017, Miller. There is also a delay about Miller 28 days, Miller. That is also a delay about 28 days. That is 11/10. They have sent the same 8 November, Miller. And because of that, puja vacation closed. And so far, Miller, that kind appreciation. So far, the delays. What was caused for obtaining the certified copy before the learned trial court, that is para 4, Miller. Should I repeat it, Miller?
You can repeat it for satisfaction. I am not convinced, sir.
Miller, unless you lordship is
I have read it already twice with your help.
Subject to payment of cost, your lordship.
No, sir. This is 2007 matter. We're not
yes, 2007 matter, but we took all sincere steps to make the notice sufficient in respect of respondent number 2 and 3, Miller.
Very
we
good,
had
sir.
given the correct address. We are ready to
Very
take
good.
notice.
Very good, sir. Very good. All right. There is a delay of 142 days in filing the present appeal against an award dated 8 March 2007 passed by the second MSCT Northern Division, Sambalpur. In Miss J case number 87 of 1993. Full stop. The reason given for the condemnation of delay is only administrative technical reasons about the delay in getting the certified copy, delay in processing the file in the divisional office, and so on. Full stop. These kind of reasons for the delay are not convincing at all. Full stop. In a recent series of judgments, the Supreme Court has insisted that the reasons for delay has to be convincing and appropriate. Consequently, the court is not satisfied that there is any bona fide reason for the delay of 142 days in filing the present appeal. The delay is accordingly not condoned. This case number 2071 of 2007 is dismissed. Consequently, the appeal is dismissed.
Store matter item number 52.
Miller, may I take your lordship kind permission to
Sir,
file
Miller,
another proper
I am the appellant insurance company. Here, my grounds main is policy was not valid at the time of accident. We have filed policy copy before the London Tribunal as Exhibit A. The London Tribunal.
Costs are to be paid. Where is that? Receipt showing. Do you have the cause list with you? No.
No,
Very convenient.
No,
the cause list shows receipt showing payment of cost of 500 not yet received.
I am paying now, my lord, because this I have gone through your lordship's file, my lord. But I am unable to.
In this case, I am appearing for the owner. Owner.
Yes, my lord. My lord, the owner has not appeared before the tribunals, and the London Tribunal hold as per the London Tribunal passed the award as per the season list. Scissor disclose the policy number. That policy number we have verified and we have filed before the London Tribunal, that is Exhibit A, policy copy, which shows the policy was not covering the date of accident. The owner was expert before the tribunal.
Kindly see paragraph 8.
Yes, I'm only to next week.
So 2013, the file pay 500 rupees.
I'm paying now, my lord.
Not after 9 years, madam. Not after 9.5 years.
My lord, this is my senior, that is Surat Roy. The brief was just transferred to the Somnath Roy, my lord.
So no problem. This had to be paid in 2013.
Well, previously my counsel was on depression condition.
It had to be within 2 weeks from 11 to 2030. You say delay is condoned in the present case.
I have specific.
By the order dated 11/2013, subject to the appellant paying rupees 500 to the claimant, counsel of the claimant within a period of 2 weeks.
My claim is 3,64,000. My policy was not covering the data box.
9.5 years having elapsed since then. The said amount of rupees 500 has not been paid. Counsel for the appellant states that she will hereafter pay the said sum. The court is not inclined to grant that indulgence, considering that this is a very old case. Consequently, in this case number 71 of 2006, in view of the order passed on 11/2/2013, in this case number 71 of 2006, the delay in filing the appeal is not condoned. Consequently, the appeal is dismissed. The interim order is vacated. Yes.
Item 57.
Item 15, I'm sorry, the appeal, madam.
Yes. What's the amount involved, sir?
Madam, our amount is 1 lakh rupees, but our 35,800.
Sorry,
1 lakh. 1 lakh rupees is value, madam, compensation, but it's 35,800 rupees.
35,800.
Yes.
The amount being involved is just 35,800, which is insignificant for the death of a victim. Consequently, the court is not inclined to interfere in the present appeal, is dismissed as such.
It's injury case, madam.
Interim order is vacated. Yes.
It's an injury case, madam.
Okay. Yes. Injury case. Right. 1 o'clock.